Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith Rogers. Today, what a good judge and a good scientist have in common. Judge David Tatel served on the U.S. Court of Appeals for the D.C. Circuit for more than 25 years, ruling in many cases involving U.S. public health agencies. He's also the author of a book entitled Vixen, a Memoir of Blindness and Justice. He joins Dr. Josh Sharfstein to talk about his career, the new doctrines of the U.S. Supreme Court, and his gradual loss of sight. They also talk about Vixen, the guide dog that changed his life. Let's listen.
Judge David Tatel, it is fantastic to have you back on the Public Health on Call podcast. How are you today?
I'm fine, and thank you for inviting me back, Josh.
Well, I really loved your book, which is called Vixen, a Memoir of Blindness and Justice, about your career and your life. And I'm looking forward to talking to you about it.
Yes, as am I.
So let's take these topics a little bit in reverse order. We'll talk about justice, and then we'll talk about blindness. And I want to start by asking about your career. Loyal listeners of the podcast know that you served as a judge for many years on the U.S. Court of Appeals for the D.C. Circuit. But I learned in this book that you started out thinking about science.
My father was a physicist, and he involved me, even as a small boy, in my early teenage years. He involved me in his work. I spent lots of time with him in his lab, and living with my father was like living in a science fair project. There were all kinds of projects and things going on with equipment all around the house. And I went off to college, to the University of Michigan in the 60s, planning to be a scientist. I was majoring in physics and math, and that's what I wanted to do. But I was hijacked by the 1960s, by the civil rights movement, by the excitement of what the Kennedy administration was trying to accomplish. And I wanted very much to be a part of it. And so I switched to political science so that I could go to law school. And as they say, at least in my life, the rest is history. I went on to law school and spent 30 years before I became a judge, largely practicing civil rights law, both in and outside the government.
Well, let's start from the beginning there. How do you get involved in civil rights law? What does that actually mean?
Well, to me, what it meant was that as a young college student in the 60s, I was enthralled with what was going on in the South, with the civil rights movement, with the sit-ins and the freedom rides. And I was especially intrigued with the role of the Kennedy administration, the Robert Kennedy Justice Department, in trying to enforce the 14th Amendment in the South, and especially what the lawyers were doing. I thought that was just fascinating. And I was at the University of Michigan, which is ground zero in political controversies of that kind. So there was a lot going on campus in terms of marches and demonstrations. And I found the whole thing thrilling. And I found myself quickly and deeply committed to the civil rights movement and to what it was trying to accomplish in our country.
So following law school, where did that take you?
Well, I started to work with a very big law firm, which I liked a lot. But to make a long story short, I was very fortunate as a young lawyer. My law firm asked me to be an investigator for the Chicago Riot Study Committee, which the mayor set up in the wake of these riots that followed the assassination of Dr. King. And I spent the summer of 1968 as the investigator in charge of finding out what happened in the schools and with small businesses. And I spent the most of the summer prowling around the south and west sides of Chicago. And I just became even more involved in urban civil rights issues. And when I finished it, although I loved my law practice, I really did, I wanted to be a full-time civil rights lawyer. And fortunately for me, the Lawyers Committee for Civil Rights Under Law, which had been created by President Kennedy in 1963, opened up an office in Chicago, and I was fortunate to get that job. And that was my first civil rights job.
I was really fascinated to read that, particularly on education, you began to work around the country. Could you talk about your work on desegregation?
Yes. At the beginning of the Carter administration, I was named to be the director of of the Office for Civil Rights in what was then called the Department of Health, Education, and Welfare. It's since been split into HHS and Education. And the Office for Civil Rights was responsible for enforcing Title VI of the Civil Rights Act of 1964, which prohibited discrimination in federally funded programs, namely virtually every college, university, and most important for our discussion, school boards, school districts. And the department, the agency at that time, was really responsible for enforcing Brown versus Board of Education and the subsequent Supreme Court decisions requiring desegregation in the public schools. And that was mostly in the South. Later, in the late 70s and 80s, after I returned to my law firm, I became deeply involved in metropolitan desegregation, where I was representing school districts who were seeking to include suburban districts, which were predominantly white, in the desegregation process, and to require the states to fund the process. And I did that all over the country, most notably in St. Louis, Kansas City, Milwaukee, Denver, and a few other cities. It was a totally fascinating law practice.
And then soon after, you were appointed to become a judge. And the DC circuit isn't quite like the other circuits in that you are very focused on a lot of cases that have to do with federal agencies, cases that can be quite technical. I wonder whether your original scientific background and interest came to play in your mind about.
It did, in a very significant way. Even though I left science as a career, I never left it. I never really left it. I've always been fascinated with science. I love biographies of scientists, some of my favorite reading. And for years, I served with you on the National Academy of Sciences Committee on Science, Technology, and Law, which was one of my favorite court activities. So I've remained deeply involved in science. And I write in the book, I try to tease this out throughout my career, the extent to which science did play a major role in my work on the DC Circuit. For one reason, many of the big administrative cases that came to my court, like from the EPA or the FDA, have very complex scientific records. And I think my scientific background helped me understand those and also, to be honest, made me even more interested in the cases. But the other aspect of this is the more I function as a judge, the more I realize that judges and scientists actually approach their jobs in similar ways. Scientists apply laws of science. Judges apply Constitution and statutory law, and we apply those to facts. Scientists find their facts through investigation. Judges get their facts from either the administrative agency or the district court, but we both apply presumably neutral principles of either science or law to establish fact.
Would it also be fair to say that a good scientist and a good judge may have some qualities in common in that regard?
Yes, completely, because a good judge, like a good scientist, has to keep an open mind to what the facts show. And also, scientists or judges like scientists have to be faithful to objective standards, scientific standards and legal standards, wherever those take us.
And I know that you very much had that reputation of being someone who would follow the facts and the law to the right conclusion, sometimes making you not so predictable from an ideological perspective on where you would land.
Yes, well, as I write in the book, one of the big challenges for any judge trying to do his or her job correctly is to produce a legal opinion that might produce a result that's different than you would have if you had been a member of Congress. And that's because you're not just voting yay or nay based on policy, but you're applying the law to the facts. And sometimes that brings you out in different places than you might come if you had been a legislator.
You are also known for your humility in writing decisions, not trying to jump in and, rewrite the policy, for example. And I wonder in that context how you have seen the Supreme Court recently in its decisions in what is called the Chevron deference cases, where, and particularly in this case called Loper-Bright, the Supreme Court basically said that courts generally should not defer to scientific agencies on questions that involve the law, agencies like the FDA or EPA. And I wonder how you viewed that given your previous experience.
Well, maybe let me just step back and make a broader point about the book, because the Chevron Loper-Bright question you just asked fits into it. My book isn't as much about the results of Supreme Court decisions. Sure, concerned about the results, but my focus in the book is on judging and the qualities that produce good judging as distinguished from policymaking. What I try to explain in the book is my concern that this Supreme Court has departed from judging and has intruded itself into the policymaking functions of the elected branches of government. And I see the Loper-Bright decision as just one example of that. I sat on the DC Circuit for a long time, and I heard many Chevron cases. And I thought that Chevron did a pretty good job of freeing expert administrative agencies to fulfill their statutory mission without judicial interference, but at the same time preserving the power of the courts to rein them in if they exceeded their jurisdiction. I thought it worked pretty well. It wasn't problem-free, but it was a pretty good system. And it was a system that Congress was well aware of. It passed many important statutes since the Chevron decision, knowing the courts would apply Chevron to interpreting. And the Supreme Court for years applied Chevron. But now suddenly this court, driven largely by its concerns, its doubts about the integrity of administrative agencies, has overruled Chevron. Now, my feeling is that I have two thoughts about that. One is I thought the Supreme Court's reason for doing it was completely unpersuasive. Its opinion rests on the proposition that there's one proper interpretation of a statute, and that's just not the case. Ambiguous statutes can be interpreted reasonably in many different ways. And so the opinion rests on, I think, a flawed premise. And second, if there were problems with Chevron, I think the proper way to have addressed them in our democracy was through Congress. Congress passed the Administrative Procedures Act, and Congress enacted the Clean Air Act and the other statutes that agencies administer. If there were problems with Chevron, the proper way would have been for Congress to have had hearings, and it could have amended the APA in a way that corrected whatever problems it found. But now the Supreme Court has taken that away from Congress. Congress could overrule Chevron if it wanted to. There's no question about that. It's not based on the Constitution. At least I don't think it is. But still, I saw this as a good example of the court allowing itself to trend away from judging and into policymaking. And the consequences are quite serious for administrative agencies and their ability to perform their missions. I mean, we'll have to see what happens. And of course, last night we had an election, and President-elect Trump, when he's sworn in, will have a Senate that's Republican, and we'll have to see what happens. One of my questions I've been thinking about, Josh, is I wonder whether the people who wanted Chevron overruled are quite as enthusiastic about that this morning, now that they control the deep state that they're so worried.
But I was going to ask you about that. In other words, just to be clear, if a Trump administration agency makes a determination under the reversal of Chevron that happened recently by the Supreme Court, a judge might say, you got it wrong, to the Trump administration a little bit easier.
Yeah, I mean, the Trump agencies might regret not having deference now, although my guess is that the courts are going to be sympathetic to what Trump agencies are doing, but still there could be some tension there. And we'll have to see whether, this is a little bit like the dog that caught the bus. But only time will tell how this washes out.
Let me use the last few minutes here to switch from justice to blindness, because incredibly, as you're going through this remarkable career, you are losing sight gradually. And tell me what that was like. You are doing more and more people are depending on you. You're issuing opinions of greater and greater impact. And you're trying, as I read the book, to maybe not exactly deny your visual impairment, but not confront it fully. Would that be fair?
Yes, that's totally fair. That's what the book is about. So when I was young, I hid my declining sight. To most people, I look like a sighted person, but I had trouble seeing at night. I had limited peripheral vision, and I had lots of tricks for avoiding it. And I talk in the book about why I did that. As I grew older and took on positions of responsibility and began inevitably and necessarily to use a white mobility cane, I still never talked about it. I wanted to be known as a judge. I didn't want to be known as the nation's first blind judge. I wanted to be known as a judge who happened to be blind. One of the things about writing a memoir, Josh, that I had not understood is that it forces you to think deeply about your life and your experiences and why you did what you did. And, I look back on writing the memoir was in many ways the most important in confronting blindness because it made me think about it and it forced me to be comfortable writing about it. So my views are extremely different than they were as recently as 5 or 6 years ago. And it's largely because of the memoir.
Well, what I loved about the memoir was that your evolving views and your experience of blindness actually takes a physical form. It's not just something that is you wake up one morning thinking differently, but you wake up one morning and suddenly you have an animal by your side.
You mean my guide dog?
I mean your guide dog. And that you are embracing, in a way, your blindness. You're letting the world know, but at the same time, it's so freeing for you.
Yeah, that's exactly right. The guide dog's name is Vixen, and I tell the story in the last chapter called The Dog That Changed My Life, and that is not an overstatement. But Vixen, she's a German Shepherd, has freed me in two really major respects. One is I have a level of physical independence that I haven't had in decades. And so does my wife, Edie, because I'm free to go on walks myself now. And I went on a long walk this morning after the election. And I go back and forth to the office with the dog. So on a physical level, I'm free. But she's also helped free me to talk candidly about blindness. When you walk around with a mobility cane, people don't come up to you and say, that's a really cool cane. How does it work? But when you have a dog, everybody wants to talk about the dog. And I like to say, you can't not be blind and have a guide dog. And so she's made me comfortable talking about blindness and embracing it, not to celebrate it, but to just embrace it as part of who I am. And I'm a much, much more comfortable human being because of that. And it's because of the memoir and the deep thought that required, and because of Vixen, this magnificent guide dog.
Well, I absolutely encourage people who are interested in this conversation to read your book. It is remarkable just for the legal stories, and what gives it this incredible depth is how you weave in your vision across that. And I think that you will be leaving this great legacy for people to appreciate and be inspired by.
Well, thank you. If I could just say one more thing, Josh, that one of the things that really has surprised Edie and me about the book is what's happened after it. I get quite a few emails now every week, or I have conversations every week with people who say that the book tells their story also. And that's really meaningful to me because, when I was going through this, I thought I was the only one. But it turns out lots of people with disabilities, including blindness, have had exactly the same experience. And it's quite profound to learn that they see in this book their own story. I had not anticipated that.
Well, that is fantastic. Thank you so much, Judge Tatel, for joining the podcast and talking about this great book.
Thank you, Josh. Enjoyed our conversation.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, Stephanie Desmond, and Grace Fernandez-Ciceri. Audio production by J.B. Arbogast, Holly Cardinale, Spencer Greer, Matthew Martin, and Philip Porter, with support from Chip Hickey. Distribution by Nick Moran. Production management by Catherine Ricardo. Social media run by Grace Fernandez-Ciceri. Analytics by Eliza Rosen. If you have questions or ideas for us, please send us an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.